delay. We have one administrative procedure, and it's for appeal number 2877. We received a mail. Dear Mr. Ryan, per our discussion this morning, please note that the applicants request a continuance from tonight's zoning hearing board hearing and further request to be placed on a special meeting agenda on the May 17, 2012 zoning hearing board agenda. Please note that the applicant waived all requirements for the Pennsylvania Municipalities Planning Code that pertain to hearing timeline mandates. Please note that this waiver is in effect until May 18, 2012. As discussed, I will be in attendance this evening should the board have any issues. Thank you for your consideration in this matter. Nicholas Cucci.
We should, open the hearing before we continue it, so that we don't have to re-advertise if the continuance is granted.
Okay. Mr. Cucci.
Yes. Good evening, members of the board. Yes, Nicholas Cucce, C-U-C-E, here on behalf of the applicants, Radnor Fire Company and Metro PCS. As noted in my letter that was just read by the chairman, we are requesting a continuance of tonight's hearing to the May 17th hearing agenda. And unless the board has any questions, I'm free to entertain those questions at this time.
You would confirm on the record that the extension of time doesn't expire with the granted of extensions. I mean, we have the extensions of time, called for deciding the case afterwards and so forth. The extension would just be for starting the hearings and then the timeline after that, right?
That is correct, Mr.
Right.
Solicitor, yes.
And this is for the next, not the special meeting, but the next scheduled meeting of the board, which is the third Thursday of May.
That is correct,
Okay.
yes.
Any questions?
No questions.
Any? Okay. Okay. With the,
It's fine.
fine. Okay, granted. Okay,
Thank you all very much.
The next appeal is Appeal 2876, and I am recusing myself from that. Mr. Dolan?
The next matter is appeal number 2876. The applicant, Luella Court Historic District Neighborhood Association, care of Susan Byrne, President, 37 Luella Court, Wayne, PA. This appeal is filed pursuant to Section 909.1A of the Municipalities Planning Code, 53 PS Section 10,909.1A, and challenges as erroneous. Sorry, we have a technical problem. Where do you need me to pick up?
Go right ahead.
Okay. And challenges as erroneous the following three determinations by the zoning office. One, his determination on January 19, 2012, that a proposed parking garage for the property, which would be located partly above and partly below the current grade of the subject property, is not impervious coverage under the provisions of zoning code section 284. Two, his determination on January 23, 2012, in conjunction with the township's consideration of the proposed parking garage on the property, that supporting walls of the garage may be constructed within the 30-foot front yard along Luella Court, despite the prohibition in Code Section 284 against the location of structures in the front yard. Three, his determination on January 23, 2012, in conjunction with the township's consideration of the proposed parking garage on the property, that parking within the proposed garage may be located within the 30-foot front yard and right-of-way, despite the explicit prohibition in Code Section 280-105F against parking in those areas. Mr. Greenfield.
Thank you, Mr. Chairman, members of the board. Jim Greenfield for the applicants. I want to slightly modify number 3. This is not a material modification, but what the section of the code says is in the front yard and also within 20 feet of the right-of-way, and that's really how it should read in accordance with the ordinance.
Okay.
I think the way to begin this is to play the video clip of the January 23rd, 2012 Board of Commissioners hearing. There's a 17-minute section of that we want to play, which sets this whole thing up. It contains the 2 oral opinions in it, and it has some other remarks in it that I think are critical to set up the arguments that I know are going to precede the hearing.
Mr. Greenfield, before we get to that,
yeah.
Can I clarify some facts?
Sure.
This matter, has this been before the Board of Commissioners?
It has.
And has final land development plan approval been granted by the commissioners?
My understanding is that it has.
Do you know when that was?
I know preliminary was January 23rd. Dave, do you know the date of final?
Mr. Falcone, if you would state your name for the record.
Dave Falcone. The final land development approval resolution 2012-22 was given on 2/13/12. Preliminary approval resolution 2012-07 was given on 1/23/12.
Right.
You okay with that?
Thanks, yeah.
Okay.
Thanks, Dave.
No, Mr. Greenfield, the board would like to hear argument on the issue of whether or not this matter should have been appealed to the Court of Common Pleas upon the granting of approval of preliminary and final approval by the Board of Commissioners.
In
Okay.
other words, does this board have authority or any jurisdiction to entertain this at all? I think that's a threshold question. If this, we have before, as I gather, the filing of the appeal on the 20th, we have a preliminary and final land development approval. 901.1 says that the governing body has exclusive jurisdiction to decide this, and that the court, and then that in the 102 Secretary's section say that those appeals from the whoever has the final authority, be it the zoning board or in this case a governing body, should go to the Court of Common Pleas. Do we have any authority right now to hear this?
Okay, I'm happy to start there. I understand that there are, I guess, no fewer than 3 threshold jurisdictional questions that have been placed before the board. And if you want to start with that one before we get to play the video, which I think will implicate the other issues, I'm happy to do that. There's nothing anywhere in the MPC that indicates, and by the way, there's also nothing in the case law that I could find, and I spent a lot of time looking for it. There's nothing that suggests that when you have an appealable determination that's been made by the zoning officer, that the subsequent preliminary and final approval of a land development plan that triggered the entire controversy then divests the zoning board of jurisdiction to hear an appeal of the determination. And if you think about it, you look at the context of all the cases, particularly the North Codorus case that we cited to the board in response to Mr. Rice's letter. It's clear that those appeals were undertaken from determinations that were made in the course of the municipality's consideration of a subdivision or land development application. And the code, the municipality's planning code, specifically section 909.1A3, which allows appeals from a determination by the zoning officer, does not suggest in any way that the jurisdiction of the zoning hearing board expires if there's a subsequent approval of a land development or subdivision. And if you think about it, if there were a rule that jurisdiction did expire and that you were required to go to the Court of Common Pleas upon approval of a subdivision or land development, the grant of jurisdiction to this board would be transitory and in all probability illusory, because it would exist for a very short period of time and then it would disappear. And certainly if there were an appeal to the Court of Common Pleas of a land development approval, these issues would be included within that. But there's no requirement that an aggrieved landowner proceed either way.
I guess let me respond just with the concerns that I have. The North Codorus decision was a situation where before decisions were made on the land development application, the applicant asked the zoning officer whether an ordinance amendment would be applied to his application, and the zoning officer said yes. He appealed it. In that situation, the zoning board determined that the zoning officer was wrong, and that was appealed. But the board had jurisdiction because there hadn't been a decision. They cite, though, at page 4 of the opinion, Although noting various ambiguities in the MPC, including the fact that the MPC is silent as to the timing of challenges to the zoning aspect of a land development approval, this court adhered to our Supreme Court's determination that zoning issues should be resolved no later than the acceptance of the final plan by the governing body. The final approval has happened, and it seems to me that's certainly challengeable, because zoning problems are a matter that can be challenged in an appeal of a land development approval. It seems to me that the role of this board shuts down when the decision is actually made by the governing body. I'm also a little worried about what exactly does the code authorize us to do about it. I see nothing in the code that authorizes the MPC that authorizes the zoning board to overturn a decision by the governing body or to enjoin the governing body, and there's plenty of case law out there that says that zoning board's powers are to be construed narrowly. We have to clearly have the authority by statute to do something in order to proceed. So those are the concerns that I'm seeing, and I've expressed to the board in executive session. How would you respond to them?
Well, again, there's nothing. The way the MPC presents this is that it essentially sets up an option. There's no requirement that once the subdivision or land development has been decided, that an aggrieved landowner has no choice but to take it to common pleas. Clearly, if you want to appeal a land development approval directly, then you would appeal that to the Court of Common Pleas. However, there's a period of time that begins with the determinations by the zoning officer and extends for 30 days, during which an aggrieved landowner may appeal to this board. And there's nothing in the MPC or in the Radnor Township Code or in any other law that I'm aware of, there's certainly no case law on it, that says that the jurisdiction of the zoning board ceases when there's a land development approval. So, I mean, I just don't think there's any basis for the board to conclude under these circumstances and given the law that it has no jurisdiction.
I guess the question that I have is that 909.1 gives exclusive jurisdiction to the governing body to decide subdivisions and land developments, and that the appeals go under the 110 two sequitur sections. They go to the Court of Common Pleas from whatever body has authority to adjudicate them. The adjudication happened, and I don't see a role for the zoning board after that, nor do I see anything in the statute I see nothing in the statute that affirmatively says the board can do it. And there's plenty of law out there that says that the board clearly has to have the power to do something. For example, we have no power of enforcement because the statute doesn't say that. I don't see that we have the power to hear it or that we have any remedy that we can give. I see nothing in the MPC that clearly lets us overturn the Board of Commissioners.
Yeah, it's the remedy issue, I think, that jumps right out at me without having done all the research that John has obviously done, and that is, do we have the power to rescind the final land development approval granted by the governing body?
That's not what we're appealing. We are not appealing final land development approval by the governing body.
But if we were to make a decision, like as you have asked us to do, that says some of these determinations on which that approval was granted were wrong, isn't that in effect what we're doing? We're undermining that decision. We're undermining the appeal. We have no jurisdiction to do that.
Well, no, you have no direct jurisdiction to undermine a land development approval by the Board of Commissioners, but you do have explicit jurisdiction in the MPC to consider and reverse a determination by a zoning officer, particularly in a case like this where the determinations are made in the context of a pending land development application. So we're not asking you to overturn a land development approval. All we're asking you to do is to look at these determinations by the zoning officer and determine whether they were consistent with code.
I think, although you're not phrasing it that way, you are asking us to do that en passant. You're basically asking us to do it on our way to doing something else.
I'm really not, because this appeal would be valid before this board let's look at a scenario where you have determinations made by a zoning officer, and then for one reason or another, the governing body's determination on the land development or subdivision is put off for some months. Just because that application is pending and it's going to be decided one way or another by the governing body, does that divest the zoning board of jurisdiction? The answer is no. So there's nothing in the MPC or the law to suggest that your jurisdiction exists for a brief period of time and then it terminates.
What is the, if we're not challenging the land development approval, let's assume that we heard, the board heard the whole case and agreed with you and said these were determinations, they're not time barred and they're wrong. What's the effect of that determination?
The effect of that is clearly to undermine some of the basis for the land development approval. No question
Is
about
it can we tell the zoning, the Board of Commissioners on that basis that they have to rescind the approval? Can we enforce it? I mean, it sounds to me an awful lot like an advisory opinion, and there is case law that says we can't give advisory opinions.
It's clearly not an advisory opinion. This is an advisory opinion, as you know, relates to a situation where there is no genuine controversy, and the controversy is manufactured by someone in an attempt to set up an opinion, as in the DRO case, which was cited by Mr. Falcone. That's a classic example of an advisory opinion because there was at that time no application pending before Lower Merion Township that would have necessitated a zoning officer determination. So this is not that type of case because there's a genuine controversy before the township at the time these determinations were made. So it's not advisory in any way.
But the decision was made, the final decision was actually made, and the appeal period started running on that before the appeal was filed. I mean, the decision was made, and I think that the concern that I have. Let me just share with you very quickly. I see at least three issues. There might be more. One is, do we have jurisdiction at all, given that the final approval has occurred, or does it have to go to common pleas? Second, there's been mentions in some of the letters about time bars. I don't know what all those are or may be, but are any of these issues these determinations time barred, assuming they are determinations? And if you get past that, then are any of are these things actually determinations? And I think, in my view, failure to clear the first hurdle doesn't get you to the second one, and I think each one of them. And perhaps there are hurdles that don't apply to, time bars or determinations. Some could go forward, some could not. That would depend on what was presented to the board. But the issue of whether this should have gone to the Court of Common Pleas, to me, covers all of them. And if this appeal should have gone to the Court of Common Pleas and we lack jurisdiction, I think that's where I think I would recommend to the board that that's where we have to stop, and that's why this is why I think this initial question is really of great importance.
I think you're right. I think it's a threshold question, and that's why we're dealing with all these issues out front. Let me make a couple of other points. There could have been, and probably were, a number of other bases on which the Board of Commissioners considered the land development application in this matter. Although the relief we seek would undercut the land development approval, it certainly doesn't cover all the grounds under which the Board of Commissioners may have granted approval. It only covers a few of those grounds. And I think that's a critical thing to consider. We're not attacking the entire approval. We're attacking certain segments of it. And would this compel a reconsideration of the land development approval? It might.
I have to take issue with that. Wait a minute. If the Board of Commissioners erred in granting this land development approval, because in doing so, they permitted the applicant to violate the township ordinance in what you're alleging is numerous ways, then the fact that they may have had other good reasons for favoring the granting of the approval are irrelevant. They don't have the power to allow you to violate the township ordinance. Only we can grant the variance, or the court can grant you relief under appropriate circumstances. But the Board of Commissioners unless they change the law, and they can't do that retroactively for the pending application, cannot give you the right to violate an ordinance, cannot give the township the right to violate the ordinance. So if we were to exercise jurisdiction here and feel that we had it, and if we gave you the kind of relief you're asking for, we are destroying that approval and butting heads with the Board of Commissioners, which is not something we have the authority to do. The court has the authority over all of this. If you don't like our decision, you go to the Court of Common Pleas.
Right.
You don't like their decision, you go to the Court of Common
Right.
Pleas. We all are subject to that jurisdiction, and they are the body with the appropriate jurisdiction. And you can't say, well, you're not automatically undermining the approval by taking jurisdiction here and deciding in our favor a few of these things. We are inherently. It's absolutely unavoidable.
Well, again, we're not appealing the Board of Commissioners' determination. We're appealing something that took place before the Board of Commissioners.
You're trying to
made
do
any decision.
indirectly what you didn't do directly.
No, that's not correct, Mr. Cutler. This is a very limited appeal to discrete issues. It's not an appeal of the overall approval of the land development. And let me make one other point. If it's your position that ultimate approval divests the zoning board of jurisdiction, what happens in a situation where there's a determination by the zoning officer, an appeal is filed to the zoning board, which at that time clearly has jurisdiction over it, and then subsequently the governing body of the municipality approves the subdivision or land development? Do all proceedings before the zoning board at that point cease? I mean, I want to know what the
we had
logical...
jurisdiction, and I have not researched that issue of whether you would lose jurisdiction. Presumably, you have it. You go to court with the common pleas on the land development.
Answering
side.
that question would be giving an advisory opinion,
Yeah.
because that's not the facts. Let's
Yeah,
study.
I mean, the point of the matter is exactly that. And one of the things I would say, I don't think the Board of Commissioners has authority on the basis of some ruling by us to reconsider that decision on its own. I cite the Grand Central Sanitary Land Fill decision, which said that a zoning board can't reconsider and rehear its own cases because that's not clearly the MPC. And I don't know of anything in the MPC that allows the Board of Commissioners to reconsider an approval once they've issued it, and they've issued it here. So I don't, if we can't overrule, we're, each entity within its jurisdictional level is the zoning board and governing body are the final arbiters before you get to court. I don't think we can tell them what to do on something that's within their power, and they can't tell us. And that's why I think this needs to go to somebody that outranks everybody.
The critical issue really is not whether we have jurisdiction or they do at this point. It's do you have a remedy or are you barred? Now, I don't know the timing of everything, so I'm not going to go to that issue. But assuming you haven't blown any statutes or appeal periods, you have a remedy. Your remedy just isn't here. If you think you've been aggrieved by what we do or they do, you either have a remedy or you don't, but that wouldn't relate to our actions.
I had no remedy directly to common pleas until the time that the Board of Commissioners gave final approval to the plan. So the answer is I didn't have a remedy at that time.
But didn't you file this appeal a week after the final approval? Because I thought the second...
Probably a week after final approval.
So you then had the court remedy at that time.
We had court remedy at that time, correct. But there's, again, there's absolutely... We're in uncharted territory here in terms of the law.
Well, no. When that January 3rd letter that was written on the issue of impervious coverage...
Yeah, it was... I think it was
if you think
later
that was a
than
determination, couldn't you have come to us then on an appeal on that determination? And if you were aggrieved by our decision, couldn't you have gone to court on that?
Well,
all before it went before the commissioners?
Sure, we could have. And then what would have... This brings me back to the question that I raised with you before. And that is that if it's your position that the zoning hearing board's jurisdiction terminates upon the approval of a subdivision or land development...
No, that's not necessarily our position. We're not dealing with the general law, the general concept. On these particular facts, Our position is that we do not feel, or at least that's what we're discussing, we do not feel, we doubt that we have jurisdiction to act on what you ask at this time on these facts in this case.
Well,
We're not making a general ruling. It's not-
I understand that, and I'm not asking you to make a general ruling, but the reason I'm raising the question is because you're in a situation here where you have absolutely no law to guide you. There's nothing in the MPC that guides you. There's no case law. So my question is, what's the logical extension of the point that's being made to me, which is, doesn't the zoning board's jurisdiction terminate at some point when the Board of Commissioners decides the land development? And I think, the entire set of consequences has to be thought out to determine whether there's any basis for that. There's nothing in the law that supports that. There's an explicit statement in the MPC in 909.1A3 that this board has jurisdiction to hear appeals of determinations by zoning officers. Nothing in there says that jurisdiction terminates at any particular point in time once the appeal is filed. So, I mean, I
guess the question is, we're not dealing with a situation where an appeal of a zoning officer was filed before final land development. We're dealing with it after final land development in an area that 909.1 says is the exclusive purview of the governing body, and then the appeal period provisions say you take your your appeal to the Court of Common Pleas from whoever was entrusted with the final decision. And
well, we also appealed after preliminary approval, which arguably was an appealable event.
have you appealed that where has that been appealed to?
What? No, I didn't say we did. I said we appealed after. We filed this appeal with the board after the preliminary approval.
And also after the final.
And also after the final. So, but what would have happened if we'd filed it? If we'd filed the appeal after preliminary but before final? I mean, I don't understand the basis for the claim that there's no jurisdiction. Because there's no limiting factor in the law.
Can I address that?
Yeah, I think it would be nice to hear if the other parties have any.
There's, just to stay on this issue of the final land development approval, I think the result, if he appeals after the preliminary, is the same as it should be now. Because once you get preliminary plan approval, that plan's vested unless somebody files an appeal. Their remedy was and has always been either appeal the preliminary plan approval or the final plan approval if it's different than the preliminary plan approval. You can't come in collaterally and attack 3 or 4 bases of a supervisor's decision on a land development approval. You can't do that, and Jim's right, it doesn't address it in the MPC, but what it does say is what a determination is. And I think that Mr. Greenfield keeps saying you have jurisdiction over a determination, but there's been no this is not a determination what's in front of you. Look at the definition of what a determination is in the MPC. It says it's a final action by an officer, body, or agency charged with the administration of any land use ordinance or application. If Mr. Kachansky goes to a board meeting and renders an oral opinion or puts a memo together for the benefit of the board, which is what happened here, it's not a final action. So we don't even get into 909 with this case because what Mr. Kachansky did was he issued a report. And that definition says reports in the MPC, right after the determination definition. That says reports are not appealable. What a report is defined as is a letter, a review, a memorandum, a compilation, or similar writing made by any body, board, officer, or consultant other than the solicitor to any other body, board, officer, or consultant for the purpose of assisting the recipient, in this case, the Board of Commissioners, of such report in the rendering of any decision or determination. So their vote on the preliminary and final is a decision or the determination that had to have been appealed to county court, not the zoning officer, township engineer, or anyone else that responds to a request from the elected body, which is what happened here.
John, you're reaching the third hurdle. In other words, what John Ryan said was, we have the first hurdle of do we have jurisdiction to act at this point in this matter, period. Second hurdle, the issue of potential time bars. Third hurdle, this issue of is there a determination to be appealed.
Right.
But, I mean, we're not even there yet. Do you have any argument you'd like to make on the first issue as to whether we in fact have jurisdiction
I don't.
to do anything in this matter?
I think on all of these, you have no jurisdiction. I mean, these are all jurisdictional issues. Whether this is a determination, whether or not the appeal should have gone, the appeal from final or preliminary plan approval should have gone to the Court of Common Pleas. And now that it's happened, and this appeal gets filed a week after the final plan approval, I think the fact that you have no remedy, you have no power to reverse that as a board on his appeal. What happens at this point? Do you issue an order? It's done. The 30 days has run on that. There's been no appeal from the final land development plan. Unless there's some nunc-pro-tunc argument that someone wants to make regarding that, that's the remedy. And to the extent that the applicant keeps saying they had no remedy, that was the remedy. That was always the remedy. Anything in that final or preliminary land development approval could have been appealed within 30 days after those decisions were rendered. So I don't think you have jurisdiction on that basis. I don't think you have jurisdiction because of the determination that this is not a anything that Mr. Kachansky did doesn't meet the definition of a determination. That's appealable. What he did was a report. And I think there's a couple other issues. There had been some other prior zoning determinations. And there's another issue that I don't think anyone's raised, but in these types of projects, you have to raise at the earliest possible time appeals from decisions or permits that get issued. You can't wait till a year has passed and an applicant and the Planning Commission and the staff and the commissioners go through a review of a complicated set of plans. So I think there's another issue involving the first approval in this township for this project that I could find was a HARB approval in July of 2011, which shows this building, which shows the underground garage, which shows there's an allegation that there's some retaining walls or supporting walls in the front yard and parking in. That was all on those plans that HARB looked at, recommended, and the board approved. So as soon as that issue was in play a year ago, well, not quite a year ago, and you've got to raise appeals to those types of issues early on. There's some old Supreme Court cases that deal with when you have to appeal permits that are going to end up being land development approvals. And I think you've got to do it as early as possible. Otherwise, you end up doing what happened here. You wait to the end and everything has happened, and then there's an appeal filed of a zoning issue, essentially, a disagreement over of how the zoning ordinance should be interpreted. So I don't think you have jurisdiction on any of these grounds to hear this appeal.
I guess, Mr. Rice, the thought that I have is if after the final approval has been issued, the appeal has to go to Court of Common Pleas and we have no jurisdiction, the board can't get into inquiries on whether the proceedings below were done properly, whether everybody had an opportunity. I mean, it doesn't matter. It's, you know, everything could have been perfect, everything could have been wrong, but that, you know, an allegation that things are done wrong doesn't give us jurisdiction we otherwise don't have.
I mean, I obviously agree with that. I think that the fact that the board, this appeal doesn't get filed till after the final land development approval, I think that by itself is sufficient to dismiss this. Just wanted to let the board know there's a multitude of other problems with this appeal in the township's view going forward.
Okay.
May I respond briefly?
Well, you know,
What
Jim,
other
I
part to hear from?
thought maybe we'd hear from Mr. Falcone, and then you could wrap it all up.
So, keeping it brief, again, David Falcone.
Assuming you want to reserve a little rebuttal there, Jim. I do. Yeah.
We believe what Mr. Rice has said this evening is and what the board is opining to this point is correct. The natural impact of a decision of this board to allow the garage to be deemed impervious would essentially unravel an already granted preliminary and final land development approval. The MPC does not provide for that. It doesn't provide an aggrieved owner the ability to bring that claim to this board. The appropriate remedy there, and it's very clear through case law and through the MPC, is to take that claim to the Court of Common Pleas. I'll cite only one thing, and I think it's relevant to the extent that it speaks specifically to this issue. Before the MPC was amended, this practice was, in fact, appropriate. The 1988 amendment removed language which said, persons aggrieved by a use or development permitted on the land of another. So now we're outside of our appeal and now dealing with an aggrieved owner. On the land of another who desires to secure review or correction of a decision or order of the governing body. So that's the governing body being the Board of Commissioners. Or any other officer or agency of the municipality which has permitted the same, on the grounds that such decision or order is not authorized or is contrary to the provisions of an ordinance or map, shall first submit their objection to the zoning hearing board. That was the language of the MPC. So if that were still in play, I think we'd be in the right venue. That language was removed from the MPC in 1988.
Mr. Falcone is right on that point.
And the new language, which was inserted in that position, gives persons aggrieved, as well as the township, the municipality, the right and direction to bring any claim not to the zoning hearing board, but to the Court of Common Pleas. So I think it's very clear to say that when the redraft was made, the intent of the redrafters was clear, removing that authority from the zoning hearing board and placing it with the Court of Common Pleas. That's the jurisdictional issue. I don't think we can get past it without unraveling a land development approval, which is not appropriate for this board.
Thank you. Mr. Greenfield.
If, since we're now into the third issue that we had talked about not getting into, if Mr. Rice is correct about what is a determination and what is a report, and you follow that logic to its conclusion in conjunction with the board's suggestion that it has no jurisdiction once there's been approval of a land development application, then the conclusion you have to come to is that there is no such thing as an appealable determination. And if that's the case, then all the language in the MPC that allows appeals of determinations by zoning officers is dead letter and illusory. It's just not there. So that clearly can't be the law. If you look at North Codorus and the other cases, including the Sika case, which Mr. Rice cited, there's a distinction drawn between zoning officer determinations that are made during the course of some pending application with the municipality and those that are not. And the ones that are made in conjunction with a pending proceeding are determinations, particularly where they effectuate the application of municipal law to some feature of that application. That's a determination. It's not a report. If you take those out of the realm of appealable determinations, then there are no appealable determinations. There's also no law, despite what may have been done to amend the language of the MPC, there was no limiting law put in 909.1A3 that says that the only appeals of zoning officer determinations that are permitted are those by the owner of the property that is the subject of the determination. That's clearly not the law. There's also no case law that supports that. The Harb issue is one that I have a little bit of difficulty understanding. If the suggestion by the township solicitor is that we should have begun this appeal process when this matter was before Harb, that's clearly not the case. I think the board can recognize that the land development process is entirely different from Harb. Harb is governed by a separate statute. It has an entirely separate appeal process. Nothing to do with this. We can't be required to have started the appeal process a year ago. There's certainly no issue that we unreasonably delayed filing this appeal because we're within time limits that are set forth by the MPC. And in accordance with that, if you look at section 914.1, of the MPC, which is entitled Time Limitations, it says, "No person shall be allowed to file any proceeding with the board," meaning the zoning board, "later than 30 days after an application for development, preliminary or final, has been approved by an appropriate municipal officer, agency, or body, if such proceeding is designed to secure reversal or to limit the approval in any manner, unless such person alleges and proves that he had no notice, knowledge, or reason to believe that such approval had been given." In other words, if you file the appeal in less than 30 days after final approval of a land development, it's permissible, and the zoning board has jurisdiction to hear it. I think that's about as clear an indication as you're going to get from the MPC as to where your jurisdiction lies here. That pretty much tells you you do have jurisdiction as long as we appealed within 30 days of either preliminary or final approval, and we did. So that, I think, covers it.
If I could make one more statement, if it's okay with the board.
Certainly, yes.
So I think, not to dig into issues beyond the first, because I don't think we get there, but I think it's important to note that there is no provision for a party other than the landowner to seek a determination. As Mr. Rice pointed out, what was presented to the Board of Commissioners was a memorandum. The very nature of the determination in the MPC is to provide an applicant, a landowner, the ability to receive information from a zoning officer in order to cite the language in 916, which is a preliminary opinion, which is to get outside of the unreasonable delay of the zoning process, to understand what lies in front of that applicant. Nothing in this MPC provides that an aggrieved landowner can seek a determination on another landowner's property with respect to what that landowner can do. To take that to the next level, if you don't like what your neighbor's doing on their property, can you go ask the township zoning officer to determine if that's appropriate, and then if you don't like that, appeal that? There is a procedure for that. It's an approval process. It's the land development approval process. Once that takes hold of an application and a decision is rendered, you're outside of what would be considered determination. Mr. Holloway didn't seek this determination. He didn't request it from the zoning officer. Those determinations were made in writing at the request of Mr. Holloway that don't deal with this issue, and those are also included in Mr. Greenfield's appeal with respect to Mr. Bauman's determinations. But this is not a determination. And to assume that it would be opens up a whole nother level of what you can and cannot do on your neighbor's property, and asking the township to interpret what is appropriate and what is not. The determination process in the MPC is clear, and there's provisions for what that process might be. And it's not have a neighboring landowner submit that process to the township only to appeal it. That gets outside of what the MPC contemplates. And I think you have to read it as an entire work, as an entire body, to understand what the appropriate procedure is for this board, as well as for the township zoning officer, as well as an applicant and an aggrieved landowner. All of those parties are accounted for in the MPC and what they need to do throughout their process. This is not the appropriate procedure.
Sure.
Very briefly, on 916.1, that's a totally different animal. That section of the MPC is set up to allow a property owner who is contemplating development of his property to get a preliminary indication from the township or whatever municipality as to whether he can do what he wants to do with his property and avoid the extraordinary expenditure on preliminary plans for a land development application without knowing what the zoning restrictions are going to be. That's a discrete, explicit type of procedure that's initiated by a landowner who has something in mind for development. That's not what this is, and that's not the only type of determination that's appealable. It's a different creature entirely. This is not the type of case, what Dave was talking about in terms of getting into an area where you're dissatisfied with what your neighbor is doing, and can you then initiate a proceeding with the zoning officer and get some kind of an opinion and then come to the zoning board? No, you can't. That's the type of advisory opinion that Mr. Ryan was talking about earlier. That's what happened in the DRO case, but that's not this. Here you had a pending application before the township, a pending land development application. And while Mr. Holloway may not have asked for these specific determinations by the zoning officer, the fact is that they were issued in accordance with the township's ongoing consideration of all the issues inherent in that land development application. And they were clearly determinations because they applied township code to the land development application. That's what this is. The language of 909.1A3 is broad with no limiting language in it, and you have jurisdiction to hear it.
Tennis match over? Does anybody else have a lob to make? Or okay.
No, did you want to make a motion?
Yeah. Well, first, I'd like to frame this in terms of the context as we see it. I think there are all kinds of interesting issues in this case, and part of me wishes we got to reach them and deal with them. But alas, as a quasi-judicial body, we have to observe judicial economy, and we have to decide a case on its narrowest basis. And based upon the advice from our solicitor on the law applicable and based upon the arguments we've heard today, I would move that we make a determination that we do not have jurisdiction in this matter, that jurisdiction, if any, still lies, given the fact that we're not dealing with the time bar issues and everything else, would be with the Court of Common Pleas of Delaware County. So I believe that we go no further and decide that we are without jurisdiction to act. And I think people have to understand, for those of you who are here to hear what happens in this case, to explain it to you, you have the right to do what you want with your land. The township has the right, the government has the right to reasonably limit you to the extent necessary for the public health, safety, and welfare. And the state has passed a law, an enabling law, and also a restricting law called the Municipalities Planning Code, which sets up this whole regime. And under that regime of law, there are bodies created like the Zoning Hearing Board, and there are powers given to the governing body, which in this case is our Board of Commissioners. And you have to understand that once the applicant files an application for an approval, whether it's a land development plan or a subdivision plan, gets approval and appeal periods run without appeal being taken, they then have rights in that. We wouldn't have the power, in this case, presently, even if we were to feel that we had jurisdiction to hear it, to enjoin them, to stop them from exercising those rights if their approval has been gotten and the appeal period is expired. So there's their rights to take into account too. Today it's them, tomorrow it could be one of you who wants to subdivide a property or do some land development on it. So, I mean, you have to understand it isn't just a question of the push-pull between somebody who wants something and somebody who wants something else. So I would move that we make a determination officially that we do not have jurisdiction and leave the parties with their remedies before the Court of Common Pleas of Delaware County, should they have any.
Okay. Cora?
Yes, I do agree with Noah's analysis, and we do not have jurisdiction to make that determination.
Okay, I agree as well. Motion passes, and we're divested of jurisdiction of the appeal.
Okay, Appeal 2878. The applicant, Nancy and Richard Clavanis, property located at 606 West Wayne Avenue and zoned AC Agricultural Conservation. Applicant seeks a variance from Section 280-10B4A and/or Section 280-10B5 of the zoning code to construct an addition to the existing residence which will encroach in either the side and/or rear yard setbacks. Go blank.
No.
Everybody go blank.
Just anyone's laptop here?
No, it stays. It's
stays
the
now?
townships. It's a new.
Okay. New device?
It's
Okay. Guys, stand up. We'll swear you in.
Nick, you ready?
Yep.
The screens aren't working?
I don't,
It's working.
who went out? All of us went out.
Yeah, I'm out.
Yeah, our monitors are blank. We're not getting anything all of a sudden.
But you can start.
Oh, the ones in front of us.
There they
Okay,
go.
Norman?
I'll swear
Yep.
the applicant to be right, please raise your right hand, I'll swear you in. Please tell me to swear or affirm the testimony you're about to give is the truth, the whole truth, nothing but the truth.
I do.
And state your names, please, one at a time.
Nancy Clavins.
Richard Clavins.
Okay, just by a brief overview, this is a situation where we have a house in Wayne off of West Wayne Avenue. Actually, it is zoned agricultural for some reason, as you'll see in the plan. Behind the property is the Mill Dam Club, and that may be part of the reason why it's zoned agricultural, even though it's surrounded by residentially zoned property. The Clavins have this property under agreement of sale, conditioned upon zoning approval. The owner of the property is in Europe on business for this hearing, but I believe she has written a letter, and I have a copy of the letter that I will hand up to the board from her in support and explaining her situation. As I said, basically we have a long flag lot here. It is very
Excuse me a
hampered.
second, Nick.
Excuse me a second.
Yeah,
We have an
I'm
issue.
I'm a member of the Mill Dam Club, so it might be appropriate for
think
me to
there's-
recuse.
It's your decision.
Nah,
Does-
well,
does-
I don't have any, I don't think anyone from the Mill Dam Club's even here.
Is anybody from the Mill Dam Club here? Okay, have you received
We're-
any
we're-
input
we're-
whatsoever from the Mill Dam Club?
We're so far away from the Mill Dam Club. I mean,
Have you received any input one way or another from the club?
no.
Okay,
And the Bill Dam Club received a copy of the notice of this hearing?
okay.
Can we
Yes.
verify that? Yeah.
So long
It's
as,
up to you
so long
whether
as
you
you're
think-
aware and you're okay with me sitting, I'll sit.
Okay. As you'll see on the plan, I don't think it's an issue. One thing I did want to hand up to the board is I've replaced A6 with A6A. If I could hand that up to the board. I've marked it as different, John, just instead of making it A6 again, I figured it'd probably be best to make it A6A.
Okay.
And this is actually the survey, the plot plan.
We're doing away with A6? Let me have, I'm going to put two in the file.
What's the difference then between the two?
There was a measurement. There was, I'll show you.
Nick, over, can I get a copy of that?
Oh, I'm sorry. Okay, and the Clavins have been sworn in, and I'll ask them, Dick, I guess we'll start with A3, which is is a basically redacted copy of your agreement of sale for the property, and it's with Alexandra Luck, L-U-K. I've included the signature pages and also the addendum regarding the zoning, correct? And the owner is an Alexandra Luck, correct?
Yes.
And we've attached a copy of her deed as Exhibit A2,
Yes.
correct? And she purchased the property in 1993.
Correct.
And she's a single person, correct?
Yes.
And has lived there by herself?
Yes.
And Mr. Falco, I don't know if you received a letter from Ms. Luck for the file?
Yes, we did. Let me read the letter quickly, if you would like. That way it can be put into the record. Dear Radnor Township Zoning Board, due to a business commitment, I regret that I'm unable to attend this meeting in person. I have lived in Radnor Township for almost 20 years at 606 West Wayne Avenue, and I've always loved my house and appreciate being close to the Wayne. I would like to emphasize that I need to sell the house, and the agreement of sale will be voided if the buyers do not get relief for a garage. Regrettably, I will not be able to move forward with my life and future plans. Selling my house was a difficult decision, but the Clavises' enthusiasm in the property has brought some excitement to this process. I truly believe that they are perfect buyers since they seem to have fallen in love with this property just like I did 20 years ago. The house lacks a garage, and the current size is insufficient for the couple. The Clavises are asking for a variance to expand the house by adding a one-story addition for a two-car garage and a master bedroom. I strongly hope the board will approve the variance. Thank you for your kind attention in this matter. Sincerely, Alexandria Luck.
And Dick, the current gross square footage of the house is 1,894 square feet?
Yes.
And I've marked as A4 just a copy of our zoning map that shows where the subject site is located. You'll notice that the dotted portion is the agricultural zone, and the white portion is the R1 zone. And this lot and the lot in front of it is actually zoned AC, and as you'll notice, it backs up to the Mill Dam Club. Dick, why did you purchase the property?
Retirement.
And can you expand a little bit on that? Is it a one-story home currently?
Go ahead.
We want to downsize. We currently live in Berwyn and have a house that was, designed for our big family and horses and whatnot, and now it's just us. And this was the perfect combination of being close. We could walk to Wayne, which is now, I need to be able to walk easily, and also have a good feel for country, because on one side is, Mill Dam Club backs up, so.
It had a degree of seclusion that was really, we thought, remarkable. We didn't expect to find it. And it's very, very secluded back in there because of the mill dam on one side. And you're at the very end of a very long driveway, and there's just nobody around. It's just very, very nice.
Okay. Can you describe the actual structure itself?
As I recalled, it was at one time, many years ago, either a garage or a barn. Then when that area was developed, they had a two-bedroom bath or whatever it is, kind of a building.
Well, we'll get into that, but I mean, can you just describe what's currently there now? Is it a one-story addition?
Yeah.
The current home is basically one story with a kind of a half story up with a couple of bedrooms up above.
It's a step up of how much? A couple steps?
There's a second floor, which I can't get to at all because it's an iron spiral staircase. And then there's a 4-step up master bedroom that is separate from the only bath that is downstairs. So at this point, for me, it's a safety hazard.
Okay, and your proposed addition is a one-story addition?
Yes, that's basically what we need, just some garage space, because that'll be a little bit easier as we get older, and a bath and
A master
master
bedroom.
bedroom suite.
Okay, and I've marked as A5, and this kind of shows you how this occurred. It was, as Mr. Clavin stated, a stucco garage, and it was being used as a residence, and the Board of Commissioners subdivided the property into what you see now, as I've marked as A6A, which kind of shows the property itself, and I'll outline it for you. If you see A6A, out here is West Wayne Avenue. So actually, that's the bend where the grammar school is, but it comes in this manner, and then there's a flag going back to this lot. And you'll notice it's a flag-shaped lot. The problem is a couple items. You'll notice there's a spring, a creek right behind the property, and there are significant wetlands also, as you may be aware, some of you in that area, particularly where the mill dam is and things of that nature, there are significant wetlands. I'll ask Dick, how far, the closest residents are the Sneaths and the Shields, and how far do you think their house is from your property?
All right, it's over 1,000 feet, isn't it? Easily. I don't know what the distance is, but it's pretty far.
Okay, so both homes are a significant difference. You're not impacting them at all, particularly where you're putting the addition. And actually, then you see the Mill Dam Club down, I guess, to the south of the property, correct? When you pull into the property, actually, the front door is on the eastern side, is that correct?
Yes.
And you'll notice there's an existing nonconformity of only 10.5 feet on the northern side, and you're placing the addition on the southern side of the property, which impacts nobody, as we stated. We noticed, too, that we made it 25 feet, the property line. Do you recall why I recommended we do it 25 feet, or why we said
25 feet is what residential usually is, and we just said we don't particularly want to push the boundary as to what is fair residential things. So
okay, and that's actually an R1 residential setback. That's why we kind of determined that that's what residential normally is. And then also, I think one of you had asked why we had changed the plan. You'll notice that there's an existing 18.4-foot setback in this area right here. I guess that would be from the eastern property line. And initially, the plan called for an 18-foot setback, and so we changed that so we wouldn't be increasing the existing nonconformity, so we wouldn't need relief for that. The only side we actually need relief for is the side that says 25 feet, because in the agricultural zone, the requirement is 50 feet, even though in the AC zone it is 25 feet. Dick, can you describe to the eastern, or I guess that would be the western portion of the property here, and you can use this pointer if you like, because obviously you've got a large area that goes to property of the Longs and of the Hecks. And can you just describe what is back here, or why we can't build in that area?
Well, the biggest thing is because of a spring that goes down in here and the wetlands that are associated with it. It seems to be a fairly active spring. We talked to the neighbors over here, and they said it's very active, especially in the springtime. And we had pictures on it, and it was running water. We saw it. It was pretty clear. And we have a property that we have under conservation. We're very active in the conservation movement, and I just don't like the idea of blocking up a natural running stream. It just doesn't feel right. And besides that, it's a gorgeous view going this way. It's just going out seeing just plain woods. It's just plain woods up in here. A lot of deer, a lot of rabbit, and we hear an occasional skunk or two. It's quite nice. So going what would be on the west side would kind of destroy the creek and destroy the view, and it just didn't make any sense.
Is it wet over there too?
Oh yeah, that's what I said. That's what they actually showed the subsurface of the spring head. You can actually see where the water is actually running currently, and then it's active. So it just didn't make sense to go that direction because there's running water there.
Just showing you what's been marked as A7 is just basically a floor plan of what you're proposing, and as we stated, this is all one-story proposal, the proposed garage and the accessible bedroom and bathroom.
Yes.
And then A8, there are several pictures that we have, and if you can just describe what these pictures are, maybe you can point to them on the map so we can show the board where they represent. I guess first would be, well, go ahead, why don't you say?
Will you put it down? What we did is we did it facing each direction. So from here you can see the house. It's facing in. So you'll see the house from the direction of the east and the west.
And in particular, like on the east, we see the front area of the home, actually.
And that's pretty much, it's a very nice kind of cottage look to it.
And the south is where the addition would be going?
Correct.
Yes.
And then you
On the
just-
other one, yeah, on looking out, which would be,
And that's been marked as A9?
yeah.
Mr. Cornelia, this is A7, isn't it?
Nope.
Yes.
Thank you. Mine wasn't marked.
And I'll be showing what's been marked as A9.
On looking out, you'll see, you don't really see anybody. Going east, there's nobody there. Going north, there is a house here. We've talked to them, and this is on the other side of what we're planning on doing, so it doesn't impact them. Going west is this way, and as I said, going south is the Mill Dam area, which is this huge open area, and then the lake is back over here by the chairs. So it doesn't seem, there's nobody can see it.
Okay, and I've marked as A10 and A11, actually, two prior zoning approvals for both the Sneeds and the Shields, which are your closest neighbors, indicating that they were granted variances previously. Right. Have you spoken to the neighbors?
Yes.
And what's been their comment?
They were all very enthusiastic, actually. They was more worried of the unknown than there is of the known, and they all encouraged us and said, please let us know, as soon as we had become their neighbors. So we explained to them there's a slight delay, but...
Our daughter had also knew the son of the people right next door. And she'd been at their house and knew their dog, and so we went to meet them, and they said, oh, yes, da-da-da-da. And so there's already a connection where we know them, or at least our daughter knew them. So that was really pleasant.
Okay. That's all I would have, just request the exhibits be made part of the record, please.
Any questions? Noah?
No, I have spoken with Mary Kay Shields because I wanted to show her the encroachment on the plan. She's a very good friend, and she has no objection whatsoever to this. She's fully aware of it.
Jim?
I have no questions.
No, Cora? No.
The hardship has to do with with handicapped accessibility to a bedroom?
Right.
Is that principally it?
What happened on one floor? Also, we had to take care of our parents when they went through that process. We're in our mid-60s. We know what's going to happen over the next 10, 15 years.
I know it's happening to me right now.
Anyone in the audience have anything to say? Yes, ma'am. Please come up, state your name, get sworn in, please.
You'll raise your right hand. You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your name, please.
Nancy Heck.
And
Hi,
how do
we're
you spell- Excuse me, how do you spell?
H-E-C-K. We are potential neighbors across the creek, and my husband and I are in attendance. We just wanted to make sure that the existing woods that are on your
Yeah,
property
no,
will remain
That's why we
there.
were attracted to it, was the woods.
Yes.
Okay.
I-
We actually cannot see this property from our
Right.
house, and we'd like it to remain that way,
Right.
even though we've
Yes.
all become good neighbors.
Yeah, you can come over to our house and you'll see that we put a huge amount of our land in conservation. Nobody can touch it. We were the same feeling about doing it.
Yes.
And that's what attracted us to us.
Great.
Because it's wooded.
Okay. So you know where our property is then
Yeah.
across.
You're just on the other
And
side
so
of the
we
stream.
will not see the addition or
That's
because
pretty
it's
far
going
away.
down the other way.
Yeah,
Yeah.
you're way over here, because there's the creek there, and you're on this
Right.
side.
Okay,
Oh,
great.
nice to meet you.
That's it.
Nice to meet you.
Anyone else? Okay. Jim?
I would move that we grant a variance from Section 280-10B4A and/or 10B5 on the grounds that the shape of the lot, as well as the existing features, including the pond, and more importantly, the spring and other wetlands, imposes an undue hardship on the applicant.
Noah?
Yeah, I'm in favor of it as long as they honor that 25-foot setback on the, it's kind of the south side, I guess it's the southwestern side there. So as long as we conform to this plan.
Okay, you want that included in the...
Yeah, I think
Okay,
that
you're right
should,
with
It's
that, Jim?
A7 is the plan.
I am.
That's the
Okay.
that
operational
we
plan.
don't come closer to 25 feet.
Okay, we'll put that, the decision will stipulate that.
No, that's, if you should
That's
refer to
shown in
that plan.
A7?
Yeah, that takes
Right.
care of
Yeah.
it.
Okay. Anything else? Noah? No?
No, that's-
Cora?
I concur with Noah's analysis and.
I do as well. Thank you.
Thank you very much.
Thank you very much.
Okay, Appeal 2879. The applicant, Luthra 4 LLC, property located at 115 Stratford Avenue, zoned R4 residential and CO commercial. Applicant desires to reopen the former restaurant use. He seeks a special exception pursuant to Section 280-101A2 of the code to construct an addition to the existing building, which addition will not increase the area devoted to the non-conforming restaurant use by more than 50%. In the alternative, applicant seeks a variance from Section 280-42 and/or 280-29 of the code, Section 280-30D or E, and/or 280-43D of the code. Such other relief that may be required to be consistent with exhibits presented to the zoning board, or contends that the relief is permitted as a right. Mr. Cornelia?
Yes.
Sir, if you'll raise your right hand. Swear you in. Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And your name?
Bharat Luthra,
Okay. Spell both names. Go ahead.
BHARATLUTHRA.
Okay. And sir, are you also testifying?
He may, yeah. He's the
Okay,
architect, so.
And your name is?
Jeremy Lecomte of Harmon Deutsch Architects.
What is it again? John?
Jeremy Lecomte, Jeremy Lecompte.
I'm sorry. Spell your last name again, please.
Lecompte.
And your first name?
Jeremy.
The board may recall that they've seen this property a couple times in the last couple of years. It was used as a restaurant from probably 1965 to about 2004. In 2004, 2005, it was sold, and the applicant came in and she wanted to do a day spa, I guess, with office space, and got approval for a 5,000 square foot addition. Eventually did not work out for her, so the former owner came back and took possession of the property again, and he proposed opening the restaurant as well, and relief was granted to him in order to do that with certain conditions which we intend to comply with, and actually will become part of this order as well as our part of the other orders. Mr. Luthra took possession in 2011. He also intends to open up a restaurant similar to what the prior restaurant use was. He's asking for, and one of the additions, actually the addition that increased, that is actually an addition to the building itself, is to enclose a handicap accessible area and to install an elevator up to the second floor, because there is no elevator or handicap accessibility to the second floor. And the other part of it is to add a floor to the building where there is a floor that currently doesn't exist. So again, we're not increasing footprint on that matter. But the purpose of this is to be a restaurant, and that's what the proposal is here this evening.
Mr. Cornelia, the restaurant use was originally authorized by variance, and in
Correct.
2832, we reinstated a variance. So I don't see how 101A is available, because that applies to a non-conforming use, and I believe this restaurant has always been there by variance. And
Okay, now, there was a grant for a special exception previously, I believe back in 2004 or 5, that I've attached as well, which was A3. and that was a special exception to increase the non-conforming use and also to increase the footprint.
Okay, well, that was simply approved. You also sought a variance. This was just an approval, so I don't think that this is a confirmation. And the uses, the last iteration of this was in Appeal 2832, where we clearly treated it as a variance
Right.
use.
And the
So-
use is permitted, so the argument here isn't obviously over the use, it's over the expansion of the use.
Yeah.
Whether by variance or, it was granted by variance. I'm not.
Yeah, the use is there by variance.
Okay, so then this is not a non-conforming use?
No, it's a variance use.
Okay, that's important, because if it were a non-conforming use and it's been previously expanded, the building, we wouldn't be entitled to, the zoning board would not have authority under 101A2D
Yeah, you only get
to allow
one
expansions more than once.
Right, yeah, this was never expanded because Alonis, which is the A3, was never built. They never follow through with anything.
But wasn't there a previous expansion of this property as a restaurant at some point?
No, it was always, there was never expansion of the restaurant use. The
Well,
building's always been the same.
if it's permitted by variance, it's not an issue anyway. if
Yeah,
it was
it's a variance. It's a variance case.
Where's the loading dock on this property? I'm not loading, that loading space. Is there a, I was looking at the plans. I also saw there were some conditions on the last approval
And
to
that's-
remove certain spaces and
And
create
we've done
planning.
that. You'll see it in the.
You must have renumbered spaces, though, because the numbers don't
No,
correspond.
but
with
if you
that.
notice, we've removed that. You see the green area on one of the
Yeah.
plans? That's the spaces that have been removed. I think there was however many spaces. You can count them and see what they've
There-
been.
but- Yeah, okay, but the numbers are still there that were supposed to be removed, so they must have been renumbered somehow.
Right. Yeah, probably because we reduced the number of spaces, so I'm sure they renumbered it. Because obviously, by reducing the number of spaces, you reduce the number of seats. Okay. You're saying the loading area? Now, let's, Noah, why don't we try to go in, obviously, if we refer to it, we've got to refer to an exhibit that's been marked, and now we're just pulling out new plans here. So perhaps when we get to that point, I can, if you don't mind, we can indicate where the loading dock area would be.
Sure.
Okay. Just a little more orderly. Okay, Bharat, you heard my opening statement here, and you acquired the property in 2011, is that right?
Yes, August of 2011.
And Luthra 4 LLC, limited liability company, who are the members of that company?
There are two members, me and my son.
And I've marked as A3, as we already discussed, and that's the grant to Teresa Takis under Appeal Number 2626, indicating an addition of the footprint of over 5,000 square feet. You'll notice attached to that is the actual zoning map for that area to indicate an approved footprint of 5,063 square feet, and you'll see where that approved footprint actually is located. And then A4 is, as Mr. Ryan had mentioned, the prior relief granted to Alberto under 2832, indicating certain conditions on page 2 of this, and we will comply with all these conditions, including the removal of spaces that would increase increase grass,
Yes.
in the area. And actually, so as a result, we're actually reducing impervious coverage on the site.
That's true.
And we're not adding any impervious coverage at all.
No.
We're just taking away the spaces that were required to be taken away last
Yes.
time.
So these conditions in 2832 have not been met yet? Like the spaces? And
Well, the property isn't in use right now. So, yeah, technically, no, I guess not, if that's what you're asking. But remember, they were to be met if this is going to be used as a restaurant. It hasn't been in use at all since, as I said, 2004.
Okay, so it just has sat there for 2 years.
Right, yeah. This was granted in 2010, right?
It's a good thing you've got Act 46.
Yeah. And then there's just some communication back and forth between Mr. Luthra and Mr. Kachansky,
Yes.
and that I marked as A5. And then A6, And this kind of shows, I guess, what we're talking about, and this is the area. And if we can, the pink crosshatch portion, that's the area of the parking spaces that are being removed pursuant to that prior zoning opinion, is that right?
Yes,
And it says existing impervious to be removed, correct?
yes,
And actually, what we're adding, you're adding a proposed stairway enclosure and handicapped elevator here, and that is already over impervious
yes,
area. Okay. But you're actually enclosing an area here,
Yeah.
as we'll show previously. So what we're doing here is we're not expanding the parking area at all.
yes,
We're preserving the area. We're not bringing it beyond where it currently exists,
right,
right? We're actually pulling up some spaces as well and complying and decreasing impervious coverage and actually complying with that prior zoning approval.
yes.
Now, as you may be aware, there's been some issues regarding removal of trees on this site. And I've put on,
God bless you.
I've marked as A7. We were hoping to have this before Shade Tree, before this hearing, but actually we were requested to hold it back until the township engineers had an opportunity to review the plan. So I've marked as A7, which indicates replacement of trees as well as stormwater management basins that are being installed in addition to this. And again, the township is reviewing this. It has not been approved by Shade Tree, but we're willing to agree to this if approval is given.
Yes.
Right now, there is really no stormwater management on the site. Even though we're not increasing impervious and not adding impervious, we're willing to do stormwater management. And actually, it's been increased under township supervision. Initially, it was a smaller area, smaller basin, and Mr. Norsini actually requested some larger basin and more calculations that make it larger. And then you'll see the tree protection that we're proposing actually screens the parking lot up by the parking lot now instead of down by the property line itself. I've marked as A8. Let me ask you this too. First, as to the proposed addition where the proposed stairway, enclosure, and handicap elevator is located, what's the purpose of that addition?
The main purpose is to have a handicap elevator because there is no access to the second floor for a handicapped person. And inside is not possible. So this is the only point we could see. And since this area is already impervious and there is already a staircase, we can enclose that area and put the elevator in this box here.
Okay. And the proposed second-story addition that will indicate on A8, what's the purpose of that?
There is a small area in this over here where there is no second floor, and we want to add a second floor there to have a little more place for the banquet on second floor. There is one reason is that, in our community, there is in so many miles in this area, there is no banquet place available for our community. And many times people ask me, because since I have having a restaurant for the last 15 years, that is there a place we can hold a small event or something? And in many of the events in our community, they make separate area for gents and separate for ladies. And on the second floor, there is not enough area to divide it. So for that reason, I'm asking to make a small area where there is no second floor to build a second floor.
How many seats will that hold?
The total seats on the second floor will be, because it's divided like this, maybe it will be around 90 seats.
Okay.
Does that mean that you have to add more parking space?
No, we are complying with the parking spaces. If in the other plan, we have already mentioned that as per the code, how many seats are allowed. So the total seats allowed is 183, which is marked on Exhibit
But
A6.
that includes the additional banquet space upstairs?
Yes.
That's upstairs and downstairs?
Yes.
First and second floors is 183?
Right.
Or 180 or 163, I forget what it is.
Yes.
183, yeah. And I've marked as A8, and perhaps maybe, I don't know if, first is 1.0, but if we can just describe what that represents. And in particular, what we're talking about as far as the addition is concerned.
Sure. The partial site plan here is indicating the existing building in relation to the additions. There are 3 areas of addition. 2 of those areas are a second floor addition above an existing first story piece of this existing building. That's in the top left and top right corner of the building. The area I mentioned earlier is currently a paved court area where we're proposing a new structure, and that's the area that would contain the new exiting staircase and the elevator.
And what's been marked as EX1, is that just showing, again, that's showing the first floor?
This is showing the current first floor footprint, yes.
And the only change on the first floor footprint is the addition of the handicap accessibility?
Yes, and the staircase.
Okay. And that is located in what area?
That is located in this current paved court area here, where currently there does exist an exterior staircase. We're enclosing it to comply with the current code.
Okay, and that would be, okay, and the next one, EX2, again, of the same exhibit, that just shows the existing second floor plan.
Correct, the existing second floor plan.
And then EX3, again, just shows third floor plan?
Correct.
And then this indicates the area that we're enclosing, and the private party area on A1.
I'm sorry, which are we referring to?
Is the first floor?
Right. A10 indicates the restaurant area and the area of the lift and staircase addition.
And A11 shows the...
A11 shows the proposed second floor plan, the private party space, and again, the addition of the elevator and staircase, and some new bathrooms at that level.
Bharat, do you feel that this addition is essential to the success of your business?
Yes.
And why is that?
As I mentioned earlier, that for our community there is hardly any space available for banquet facilities, for small events, and this will give me opportunity to cater to this population. And also, with all this competition around, I have to stay competitive with the other restaurants. So to have this no access on the second floor for a handicapped person is a real difficulty for me. So that is the reason that I want to add this.
Now, I'm going to show you some photographs, I guess, and we'll show some elevations as well. But A9 first, that just shows the front of the building, correct?
Yes.
And A10 shows, I guess that would be the side facing Lancaster Avenue.
Right, facing Lancaster Avenue.
And A11, that's the rear of the building?
No, that's the left. It's on the left side of the building, where we need to put the elevator, where the existing. If you can see, there is a staircase there. We need to cover this and put elevator there.
Okay, and that's also on A12?
Yes.
Okay. And A13?
It's the rear of the building.
All right.
Excuse me, on A11, where the staircase is, there's also a small staircase in the door going into that little shed addition. What area of the building is that?
No, this will be eliminated because, once we...
But is that where the loading area was?
No, the loading area was here, but we are taking the loading area on the back of it.
So, yeah, matter of fact,
Is that shown on the plan?
Yeah.
On A6, I guess, would be the best place to show it.
A6?
I mean, you can see it from the photographs also, Noah, but, at least from a plan standpoint, if you can show where the area would be.
This will be the loading area. Before it is here, now,
Here, you got to describe what you mean by here.
before it is in the way it is says that proposed stairway, before the loading zone is in this area.
Right, that's what I thought.
Right, and now it is going to be on the back because we are opening another door here on.
Do we show it on any plan?
Sorry?
Do we show it on any plan?
No.
It needs to be shown, and it's a requirement under the zoning to have that loading area.
Well, one, now, this isn't a land development. I mean,
Right.
we can show it, I can indicate it, or have the architect indicate where it would be. But again, that would be really a matter for zoning, is my understanding. The zoning officer and building inspector have to determine where it would be.
Well,
That's not really an issue before you.
it's not. You want to expand the facility and with no condition of having a loading area. It's required under the code.
We'll install a loading area.
Yeah, I mean, it would be
That's not-
helpful if
yeah.
it were to be shown on a plan and made one of the conditions of the expansion, that if the loading area is moved, that it be relocated to that
Okay.
area.
So where would
Would
it
that
be?
involve more paving, relocating it there?
No, this is all this area is paved already.
Does that show where it is?
It's
A11?
on the rear of building,
Which
on the
one would
other
be?
end.
Which one?
It's not
Any
here.
of
If
these
we can see the elevations, we can see from there.
What is the distance there? You're talking about here, correct? What is the distance from the property corner of the neighbor? Is that wide enough for a loading area?
Yes. There is already a ramp here. On the front, it was just the entrance where you saw two steps. Actually, it was not the loading area. It was just to enter to the store. But the loading area is already on the back where there is a ramp. It's not shown somehow on the plan, but there is a ramp here for the loading, and we are going to use the same loading area, which is existing now.
Oh, okay. Yeah, since it wasn't shown, there was no
Yeah,
way.
it wasn't, somehow it's not shown on the plan.
Okay.
Now, I have it marked, the elevations, I'll mark them as, I guess we're probably at A14. And if you can describe first what A14 represents. Go ahead, please.
Sure. EX4 represents the existing west and north elevations of the building.
And I'll mark these in hand, I'm marking them, so I'll hand them out. We're going to have one.
Nick, you don't have these, the ones you're going to mark?
I'm going to mark, I don't have these, and this.
They're not in our
you're gonna
packets?
copy. They're not in your packet.
Okay. So you're going to start with A9 on?
A14. I'm up to A13 with photographs that's already been
Okay.
pre-marked.
Right.
And then A15?
A15 indicates the existing east and south elevations.
Are these proposed here? A16 and A17? And 18, okay. A16, now, does this incorporate all of them, or just?
Well, I'm sorry, A16 is a color rendering for presentation purposes of the two primary elevations. They're also shown in line drawings.
Okay, so you could describe what this is representing?
Excuse me, guys, you gotta keep your voice up, I can't hear you.
If you could describe what it's representing?
The stone portion of the building here is the existing structure. On the left side of the drawing is the area of the proposed stair enclosure and elevator that we talked about earlier. The new addition will be wood-framed, and there will be a cast stone base on it to reference some of the existing materials. The architectural language will be executed in a way to mimic some of the details in the existing architecture and make it read as well as it can in relation to the historic structure adjacent. The color renderings show only the two primary elevations, the front elevation, which would be the west elevation, which would be visible from the street, and the north elevation, which is the elevation that would be visible from the parking area primarily. The stucco portion of the building with the stone base is where the new entry to this elevator enclosure and stair enclosure would be, the double doors that you're seeing there. The first floor adjacent to that is actually an existing piece that is just being redressed and presented more in the context of the existing structure. As you can see from the existing elevations, it's currently not in very good shape. The second floor piece above that is an addition above the existing first-story piece.
And is this represented? Is there a need to?
Well, there's two other elevations that I can talk about in the line drawings if you'd
Okay.
like.
So I'll mark, one is A17 and one is A18.
Okay, so A17 shows the proposed east and south elevations. In the south elevation, in the top right-hand side of that elevation, you can see the area of the second floor addition above the existing one-story piece that currently would be the dining area. That upper piece is the extension of the private event area that Bharat was talking about earlier. And the left side of the page is the original structure. In the east elevation, you can see the rear of that addition I was just referring to, the second-story addition that would be used for the private event area here. And on the right side of this elevation, you can see the piece that you were just seeing in the color elevations that would have the stone base and the stucco, the first floor of which is existing but is just being redressed in terms of the facade materials, the second story of which is added above.
And then finally, A18.
A18 is a line drawing of the same elevations that we just discussed in color. They're just presented as a line drawing as well. I don't know if you need me to discuss that any further.
I'll fold these and mark them.
I have a question. What is the capacity during your banquet area, when you are using the banquet area, what is the capacity you are?
We're keeping around 90 seats there, but if there is a party of up to 100, then we can move some seats from downstairs to upstairs.
Does that 90 seats added to the
The total number of seats. It is the part of the total number of 183 seats.
So you're not exceeding 183 seats, whether
No.
you're using the banquet area or not using the banquet area.
Yeah.
You would be moving seats, if you're using the banquet area, you'll move seats from one area of the restaurant to the banquet area.
That is true.
No, but you have added the space. You said that it is for the banquet area. That means you are adding more space for more people. Where are they going to park? And
No,
not
no,
only
no,
that,
no, no.
is it
Cora,
going
We're
to...
not increasing the number of seats. He's saying, do you want to describe
Yeah.
again?
You see, as per the requirement,
Okay.
that number of parkings, we have explained them on this plan A6, that how the parking is divided for the number of staff and number of
I understand.
seats. So the number of seats is going to be 183. It's not going to exceed 183 seats.
That is fine, but banquet time, I know our people, it's 100 and 200 people come there, and where do they park? I am more worried about the parking.
We do not
and
have-
how it is going to impact the traffic on Lancaster Avenue.
We do not have capacity to have 200 people in a banquet, first of all. And second, because based on the number of parking, 66 parking spaces, which we have already. So we are limiting our seating capacity, including the banquet, to 66 parking spots, which is allowed.
Yeah, I understand. What is the operating hours?
Operating hours are regular. From on the weekends, we will have a brunch, on Sunday brunch, and other hours are limited to on the liquor license, which is 2 a.m.
I only had that, John. I'm sorry. I just was presented with those this evening. John, I can ask the architect to provide, if you wish, I can have the architect provide me with other copies, and I can send them to you.
That'd be fine. If you would do that,
Okay.
label them, that would be fine.
I'm going to have to see how I label.
What's the greatest number of employees you're going to have?
Currently, I'm thinking 10 employees.
Excuse me.
10?
Yes.
No, at the
Nick,
banquet.
send him to Kevin. I'm going to give him these, so if he has to write something, he doesn't have to wait to get to you.
How many extra servers are there for a banquet?
Right now, I'm not sure, but it will be within that. We have to leave the limit, that.
So I mean, if you have a full house on a Friday or Saturday night, plus a banquet upstairs, don't you need additional servers?
We might, but currently what I have based everything is on keeping that, just because since I'm in this business for a very long time, and keeping the numbers that for me 10 people are more than enough.
Even with the banquet?
If you needed more parking, where would you put it anyhow?
Not on this lot, where there is no room, there's a 66 shown here, this is what I'm gonna have, 66.
Yeah, the last approval we gave prohibits any additional impervious surface.
Yeah, we're not increasing impervious. Mr. Luther's met with the neighbors. They do not want to increase. Having dealt with them on this property for many times, I know they do not want us to increase impervious or add any more parking, particularly the rear of the lot. We have no intention to do that at all. There's really no place to add parking on this site, because if we were going to add parking too, we would have to come back, because again, we'd be increasing the current nonconformity, or whatever you want to call it.
Well, it would violate
as
the
to-
terms of the variance, yeah.
It would violate the terms of the variance. So,
Has anybody looked at the earlier variances here, like including the one that originally made this into the permitted restaurant use, to see what conditions are on all those? At this point, it might be a good idea to summarize all those in our order, because there are some old variances.
yeah, they were summarized on the last one.
Yeah, I mean, to the
I don't
extent,
know that they all were. We said generally, I think that you'll comply with all these others plus, and then we enumerated them. I was here for that one, but there are old variances that originally allowed it to be a restaurant when Chino Marchetti owned the place and ran it as San Francisco.
You're dating yourself.
I am dating myself, yeah. Who else would date me?
I do have the 1964 one that I can hand up to the board or to John, but I think it was covered in the one previously, because matter of fact, it
Yeah.
refers to the 1964 variance. We look at, in the one that's been marked A4, which is 2832, it talks about sections 1 and 4 of the 64 decision and conclusion of law number 1 of the 69 decision.
yeah, we chewed that, yeah, we did go over that back in 2010.
So let me get this straight then. This is already a lawful use pursuant to a prior variance.
Yeah.
It's a non-conforming building with regard to side yards. They're not increasing the nonconformity by what they want to do here. Isn't that right? They're not?
No, but they're making a bigger restaurant building.
Right, but they're complying with the parking requirements.
And staying within the
If they're not
envelope?
increasing the nonconformity,
Nope.
isn't it covered under 101B? Sub 1, they have the right to do this.
I don't think so, because it's a variance use. There's no, the use of the restaurant, as presented to us in 2832, was this building without the addition.
Right.
And because it's a variance use, I think they have to come back to us on
Right,
that.
and we may consider the fact that we granted variances before, and that they're not materially changing anything in terms of what was presented before. But
Well,
I think
as
we
a-
have to grant a new variance.
Well, I mean, if you
we
read
deem
the
it appropriate.
section, it says a non-conforming building, which this is, being used or proposed to be used for a conforming purpose, which it is by variance, may
I don't think it did
continue.
that. I disagree with that. It's not
Okay.
conforming. The
May
variance
continue
use-
and be altered or enlarged if the alteration or enlargement does not increase the nonconformity of the building or structure with respect to the setback, land coverage, and density requirements of the chapter, et cetera, et cetera. So you're saying you wouldn't consider this to be conforming by virtue of the former variance?
No, I think conforming it is a variance use, and a variance use, when granted, is limited to what is granted at the time. It's a creature of the four corners of the order or decision that create the variance. And if you're going to change, and it's based on the building as it was at that time, so if you're going to change the building, I do think they have to come back.
That mean you could deprive someone of the right to continue the business in a slightly bigger building, even though they didn't increase the nonconformity?
Well, they're putting
Isn't that
more-
exactly what that section was intended not to allow?
But it's not a non-conforming use, it's a variance use. The use is a variance use.
It's a conforming use,
Building is
isn't it?
non-conforming as to dimensional requirements, but not the use is a variance use.
So what variance are we giving them?
You've given a variance to expand the building as submitted in the plans, subject to presumably the conditions set forth in 2832, plus whatever other conditions the board feels should be imposed and the applicant hopefully would accept.
Did you do any traffic study in that area? Just because, you know, this was not in use for many years, is it going to clutter the street, Windsor Avenue and Lancaster?
No, it is when we take exit from Lancaster Avenue to Stratford Avenue, it's just the first building. So Windsor Avenue is after us. You know.
They have no access on Windsor.
Yeah, Windsor's actually is an unopened road. I think it's probably, it's, yeah, it's.
The only means of vehicular access is on and off Stratford Avenue.
Stratford Avenue.
And one point that we do have to remember, too, is that there were prior variance relief granted here that actually was much larger than what we're requesting here this evening, too.
But that was also for a different kind of use,
That was a
different
spa
traffic
office.
issues.
Yeah.
Yeah. And density
Technically.
issues.
I mean, it still involved expansion of the building, but the proposed use at that time was different.
Have you talked to the neighbors?
Yes, I did.
What, do you have any letter?
I do not have any letter. I met the commissioner, and commissioner sent an email to.
Okay. You spoke to the neighbors, all right, and you met with them.
Yeah, I met with them. I went to their doors also. I met whosoever was available. I met with them, and they had no objection.
Is anybody here for the comments?
I don't know if there's something.
It will be an Indian restaurant, is that correct?
Like a, see what you call it, a mix.
Okay. Oriental, Chinese and...
No, it's like European with some Indian flavor, you know.
Like a
No, you
fusion
said
idea.
about our...
Fusion, yeah.
No, you said our community. So I was...
Yeah, because of that, you know, if I'm able to cater them, you know, once they have their requirement, you know, direct only Indian food.
And I think you're aware, which I just became aware, that, not through Bharat, but during Indian weddings, the male and the genders are separate. Some of my daughters, okay, I just heard this a couple days ago,
Just
which
like get
surprised
Cora
me.
worked up.
Not from him, yeah, I don't know. But that's what I had heard. I mean, I was surprised when I heard, because he was at a
When you
wedding,
said
so
our
maybe-
community, I thought you meant Wayne.
You know, that's about 700 people. That is why I asked, you know, the banquet,
No,
700 people or 70 people.
I am not going to do weddings there, you know, like 700 people weddings or anything. I have capacity of only like 90 to 100 people in the banquet. So this is what is a small event, you know. Somebody has small event.
Anything else, Nick?
That's all.
You want to move everything?
Yes, please.
Okay. Any questions? Anyone in the audience have anything they'd like to? Please come up, state your name and address and be sworn in, please. Thank you.
Sir, if you'll raise your right hand, do you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And state your name for me.
John Shane. I've been before this group before with the neighbors.
S-H-A-N-E.
S-H-A-I-N. I think like you, I'm a little disappointed in the sense that Mr. Luther has met with the neighbors and actually has shared all of the plans relative to the Shade Tree Commission and all the iterations with the neighbors and me electronically, and the neighbors have met all about that. The neighbors, while he has discussed his plans for the restaurant, have never seen this plan. We've never seen this plan. And I would, first of all, like a chance for the neighborhood to review the plan and come back and give you comments because we have never had the chance to see this. We have said that, like everybody in the Radnor community, we would like to see a thriving business here. So I have to say that. On the other hand, in our community, we have had 4 instances of problems with parking that have gone before the zoning commission in various ways. Manela's, the output of Manela's, and the fact that parking was not considered effectively for peak times and capacity ended up having our streets, ultimately having people from Manela's, their employees, to your point about employees, park on our streets that have now made our streets permanent parking only. And in fact, we cannot get service vehicles, including ambulances, through the streets on a regular occurring basis. We then had a building that, as you know, is down at the corner of Farm and Lancaster, where we had to have the zoning commission ensure that offsets were made and entrances made so that the people would not come down the street and park on the street. The only good news for us is that building has been relatively vacant for a long time in terms of traffic, because Manela's still parks on the few unpermitted spots, so the neighbors can't use it on Farm, plus they park in that building. But as you might recall, there was a period when we came before you when the bank came in, Liberty Bank, to put an ATM in that building, and we couldn't believe that there would be enough parking or enough traffic flow on Lancaster Pike to support parking in there and people coming in to use an ATM. And I think we successfully proved to the commission, the zoning board, that we thought it was a dangerous hazard for traffic, vehicular traffic on Lancaster, which we know is governed by PennDOT and all the PennDOT rules as contrasted to township rules. So we're very familiar with that. We've been through the Wawa building and its parking and its late night, as Mr. Luther just said, for the restaurant in particular. If he's within zoning, it's 2 a.m. And holding facilities. And I can tell you Gino Marchetti did not stay open till 2 a.m. because I used to go there too and went to the Stratford Inn, even though the bar was well used by the community. The last, which has just been resolved, I believe, by the commissioners, is the parking related to the White Dog Cafe. So let me use the White Dog Cafe as an interesting parallel. They came in and asked for a permit for 88 seats. They got zoning for 88 seats. They build out not only more than 88 seats, they build out 163 seats. And they also have furniture for 55 more seats outside. And they didn't have the ability at that point to do it, but when they built it out and they planned it and they bought all their furniture, they bought all their furniture for 215 seats, not 88 seats. And so the township was always fighting uphill from a zoning perspective, a zoning officer perspective, to enforce zoning permits, which we found out after the fact that the township really didn't have the ability to do that unless there was a catastrophic event from a police or fire event to do anything any materially. So we have lived through this. So what I'm suggesting to you is, this is the first time we've seen this. But I would tell you, looking at this, is there's going to be a horrendous traffic problem there. There's going to be a horrendous parking problem. 193 people in a situation like this, if that's all that are going to be there, there's not enough parking. And there is no parking, as Mr. Caniglia said, there's no available parking on that spot. One could be a cynic and say, well, no wonder the trees were took down because there was going to be parking expanded. So we have to make sure that all of the attributes of this property are held dear to what was intended and what are the stipulations of the zoning commission. I would also tell you, the zoning board, I would also tell you that since you have, Mr. Cutler, frequented when it was the San Francisco as I did, so we're both probably of similar age, coming off from Lancaster Pike onto Stratford Avenue represents one of the most dangerous intersections in Radnor Township. And I would strongly urge that the township get a PennDOT study done, because as you may recall, when Dunkin' Donuts used to be across there, there's that ridge on Lancaster Pike that if people aren't looking, you can really get hammered on that intersection with traffic coming either direction. While I may be sounding like a bit of a cynic with this, but the reality is if it's going to be a banquet use, not a restaurant use, people come in at steady times all during the day and leave all during the day. If you're going to use it for a banquet and a wedding, you're going to have an event. How are you going to get 50 cars or 60 cars through that intersection, not backing up into that intersection? I don't think it's physically possible. And I think there is a requirement to prove that, because I think there's a liability that potentially the township and all of us are getting into with something could be extraordinarily dangerous. And I don't think we can just wipe it away, because it is the first building. It is only about 50 feet, maybe 75 feet. And how well are they going to be able to bring traffic in there with very limited parking? And I understand one of the limitations of our zoning is that Mr. Luther can say, well, I'm conforming, that there are 3 to 4 people assumed per car coming in. Mr. Ryan, how long ago was that zoning put in place?
I mean, in terms of...
How many years ago was that stipulation put into our requirements in this township?
I'm not sure.
I would submit to you that that is no longer current, that requirement is no longer contemporary, and that in fact you could easily have 80 to 90 cars going in there for 93 people, maybe more. We just heard that there's a difference between men and women coming in at different times in this culture for this. I mean, you're going to have multiple cars.
We can't enforce ordinance provisions that don't exist. I mean, if you feel the ordinance provisions are insufficient, we have no authority. That's the commissioners that would have to go and enforce that.
I'm suggesting to you that I think we need to continue this until we can get a better view of this whole situation. This is the first time the neighbors have seen this, I will guarantee you.
Excuse me, isn't this going to require land development approval because of the enclosure of the new area and creating a new structure?
Yeah, I think it would.
Yes, we are going to require them to go through the land development process.
And during the land development process, there will be a chance to be heard on traffic issues. They will have to do a traffic study. There'll be all kinds of opportunities to deal with these things.
Well, we have to just make
Our
sure.
scope is pretty
I
narrow.
know, but in the past, somehow the rules of engagement have never been followed thoroughly. And
We can
as
only
neighbors-
deal with the ordinance that's in front of us. We can't, as Mr. Ryan said, we can't presuppose that the ordinances no longer are valid today as they were 5 years ago or 10 years ago.
No, I understand that, but I'm
You know.
talking about the overall plan here. We understood there was going to be an elevator added. That was all we were told.
Well,
Not another 93 seats.
You did not know about the banquet hall.
No, we're not adding seats.
Well, you're adding a floor and you're adding seats and you're adding a venue, and he needs to get paid. I understand that.
We're not adding seats, he's adding floor. I thought.
You need to go by the microphone, please.
Yeah.
John, I thought
You can call me John.
I'm sorry. I thought they had met with you.
No, we didn't understand that, and I don't understand the issue then if you're adding space, you're not adding seats.
How many seats did you have prior to the addition?
I took this place only last year.
Okay.
Okay, so what I understood from the previous owner that how many seats are total allowed. I'm just not exceeding. Actually, I'm decreasing the seats after decreasing those number of parkings, 6 parking spaces, making it green space.
Yeah, I would have to assume that the parking, if there were 66 parking spaces there prior for the number of seats, that the number of seats haven't increased. It's hard for us to sit here and say he's lying to us. No. What I'm saying, I said we can't make the assumption like in the White Dog situation. We go by what they present themselves. If they erroneously present that they're going to have 183 seats and someone goes in and checks it and they got 283 seats, there's an issue there. And like with the White Dog, I think that the township did make them decrease and take the seats out. The White Dog was in front of us to add outside. We did not let them do that. We declined to give them the ability to add the outside seats. So, we're very proactive as to what parking regulations are. Unfortunately, if the drawing and if we make a decree in favor or against them, it will specifically say in accordance with the drawing submitted at this hearing. So if he says he's going to have 183 seats and the parking for 66 cars is conforms with the 183 seats, we can only say, okay. We can't say, oh, no, you're telling us a story. Just like you can't do it, we can't do it.
Well, also, what we can do in an order is to say that no relief is granted from the parking requirement.
Correct.
And
we can try and put, pardon me?
Well, we would like to see, you can't change.
You need to go in front of the mic, please, because they can't hear you.
You can't change the ordinance. I understand that. But what we can do as a community is put some teeth into the orders of what is compliance, right? Rather than saying, we would just agree. And
no, that's what I said. We can put some teeth in it. We can say that you have to comply. You cannot have more than 183 seats, which would keep you in compliance with parking. We're going to put in about the loading zone. We can put as much, the fact that they got to decrease the impervious. Those kinds of things we can put in our decree. Okay, but we can't change the ordinance to read what we'd like it to be.
I understand that.
Or that it might be outdated. Those kinds of changes have to come from the commissioners, and that's what you as citizens need to go and say. Hey, look, we need to upgrade this. It's maybe a parking space for 3 seats isn't what's happening today.
Well, and we've been through that. We've all seen it. I mean, but what I understand the limits of what you all can do. But I also, what we've witnessed through some of these, is the absolute limits that we have given to our township to enforce those things. And it's very hard for the township manager, the township police, and everybody else to enforce things when there's very limited activity that they can do.
But we're not an enforcement agency.
Well, they are, and
Right.
that's
I
why we
understand,
need.
but we're not.
need to give them
Right.
the tools. Is
We
what
can,
I'm
that's all we can do.
suggesting.
We can only say, in our decree what happened.
That's
right.
That's what I'm suggesting.
And we will do that when we make our decisions.
Because I mean, I understand this property pretty well, and I would tell you that while Mr. Luther is living within the ordinance, there's just no way.
Okay, thank you.
Board members, maybe for a point of clarification, there are several more processes and approvals that the applicant will need to go through. Land development being one, the building permit approval being a second one. Both of those will have direct impacts on the number of parking that will be available, which will then drive the number of seats, as well as occupancy loads. So all of that still needs to occur for this application or for this project to move forward. So,
And if anything comes up and they don't meet the ordinance, they'll be back in front of us to either get a special exception or a variance.
correct. And during the land development, we'll be looking at traffic, we'll be looking at loading, we'll be looking at buffering, we'll be looking at parking. So all of those things will be in play and are appropriate at the land development stage.
Thank you.
I'd like to ask Mr. Luther a question, if you can come up to the mic, sir. Are you aware of the restrictions that are in the existing variances involving the use of the basement and the third floor?
Yes.
And you're going to live with those?
Yes.
Within this, okay.
Yes.
Thank you. You know, there are limitations. It's a
Yeah, that was in
very
the
severe
decree. Yes,
limitation.
they can only be used for storage and mechanical. if I
Only
remember
certain
right.
part of it, only mechanical.
You know, as your neighbor was, concerned about, is that possible if there is an overflow of traffic, you can have a valet parking guy in charge so that the traffic will not hold on Lancaster Avenue or?
Yeah,
is
that would be
possible?
land development. All that's in land
Yeah,
development.
even we could suggest that.
Where would it go?
No, that is.
No, there
up to
is,
them.
as you know, where my office is, right next to there is a large office complex that probably at the times that Saturday evenings, Friday evenings.
It's not AT&T,
Sundays-
is it?
No.
So you're going to
not
get,
AT&T.
you're going to
But I'm not saying
get
that,
an
but I'm saying
easement
he would
from,
have to speak, if he was going to do valet, he'd have to speak to Mr. Fuchs, who's the owner of that property.
Yeah, but he can't have more,
Right, he's
if
still
he
going to
has,
have more seats, yeah, he's
Yeah.
limited, our
Yeah,
code.
He's going to be,
Yeah.
if we approve this thing, it's going to be 183
It's on site.
seats. Right,
Yeah, our code specifies that parking has to be on site.
okay. Anyone else in the audience have anything they would like to add? Any comments? Anyone, any other questions from the board? Noah, you want to
No.
do this one? We'll let you do this one.
no, I
Huh?
have nothing to say till the vote.
Okay, well, would you like to start it?
Not particularly.
Okay, I'll do it.
Not this time.
Not this one? Okay. I would say, I would grant the variance for 28042, 28029 of the code, as well as section 28030 D and E, and 28043D, which pertains to the uses in the residential section, the commercial section, which is 42 and 29, and the dimensional of 30DE and 43D, which is the height requirements. I'd also say that the number of seats permitted within the establishment cannot exceed the parking requirements, which at this time is 66 parking spaces, which equates to 183 seats. All past variances or decrees from the board must be maintained. The ones about the space on the third and the basements, and any removals of anything that any other previous decrees brought in their decrees. I think I got it all. Did I miss something?
Trees.
Trees, also, that you need to go to the shade tree with your plan, and they must agree to the plan that was submitted. And all dimensions should conform to all drawings that were presented to this board. Did I get everything, Noah? I forget
Curious,
something.
by the way, why were the trees taken down?
We don't want to go there, do we?
Don't go there.
I'm asking. Given that there's a parking
I
issue.
like, there's a dispute as to why. I'd prefer really
Well, who
not.
took them down?
Mr. Luther was,
Well, there's no-
well, see, there's a question on.
Then he should have an answer as to why he did
There's a
it.
question on how many, his people took some down. There was a dispute as to whether his people took the number down or a prior owner had taken some down, without getting into any more detail.
Charlie, what's your condition on
I'm
shade
sorry?
tree, your shade tree approval? That they have
Is
to-
accordance with the plan they put up in front of us.
Which
and whatever
exhibit was
shade
that?
tree And whatever shade tree recommends, they need to comply with.
What is that, a plan that what's the?
Right.
It's
It was
A7.
A7,
A7,
I guess,
John.
I think it was 7.
So I believe it was conditioned on shade tree approval of the application. I think that's probably
Right,
the best
yes.
way to put it.
Yeah.
Yes.
Yeah, A7 is the operative
Right.
plan here, I think.
But they may want
Plus
to,
the
they may want to
drawings.
add to that.
Yeah,
And they need to conform to any additions that they put in
But I
there.
don't think Charlie's wedded to A7. You're just wedded to whatever
Right,
the shade tree
right,
says.
Right. No, Cora? Jim? Anything to add?
No, I concur.
No?
I agree.
This is historic. It's passed. Thank you very much. No further business. The meeting is adjourned.